I invite Honorable Justice Dr. A.K. Jayashankaran Nambiar, Executive Chairman, Indian Law Institute and President, Board of Governors, Kerala Judicial Academy, to deliver the introductory address.
Chief guest of the day, Gautam Bhatia, Advocate to the Supreme Court. Moderators of today's function, Advocate Jacob P. Alex and Advocate Ramola Nainapalli. My esteemed colleagues on the bench, former judges of this court, Advocate General Sri.Gautam, Shaji, other law officers of the state, judicial officers from the district judiciary, Yashwant Shenoy, the President of the Kerala High Court Advocates Association. I didn't see Anup here, but other office bearers of the Executive Committee of the Association, senior advocates, Srimati Shantama, President of the Kerala Federation of Women Lawyers, members of the legal fraternity, registrars and other officers of this court, Sri Sujit, Director of the Kerala Judicial Academy, students from the various law colleges, advocate, clerks, ladies and gentlemen. Late last year, the ILI and the KJ, the Judicial Academy, decided to kickstart this series of lectures and discussions on legal issues of contemporary relevance. This is the second such event and the first in this year. Today's discussion will focus on the recent judgment of the Constitutional Bench of the Supreme Court upholding the power of the President of India to abrogate Article 370 of the Constitution that accorded a special status to Jammu and Kashmir and its residents. What are the implications of this judgment as far as our constitutional text is concerned? What does it do to our understanding of constitutionalism in our country? Are we to see this as an aspect of transformative constitutionalism? Well, who better to answer all these queries and to help us decode the Article 370 judgment than Gautam here, who wrote a treatise on our constitution calling it the transformative constitution. I would see this, if for those of you who have not read the book, very unlikely that there are many who have not read the book, but for those who have not read it, please, I would seriously commend it for a serious reading. Gautam graduated from National Law School of India University in 2011 and later studied at the Oxford University on a Rhodes Scholarship. And in 2014, he completed his LLM in Constitutional Law from Yale University. He's now practicing before the Supreme Court. On behalf of the Kerala Judicial Academy and the Indian Law Institute, I welcome you, Gautam, to our midst. And I'd also venture to describe Gautam as a role model for aspiring legal minds. The moderators for today's session, Advocate Jacob P. Alex and Advocate Ramola. These are our homegrown talent, and they will be guiding us through a spirited exchange of ideas and opinions, ensuring that our discussion remains focused and intellectually stimulating. On behalf of the Kerala Judicial Academy and the Indian Law Institute, I also welcome you both to this discussions. I welcome all my esteemed colleagues on the bench, the former judges of this court, Advocate General Gopalakrishna Kurup and other law officers of the state, judicial officers from the district judiciary, Yashwant Shenoy, President of the Kerala High Court Advocates Association, other office bearers of the Executive Committee, senior advocates, Srimati Shantama, President of the Kerala Federation of Women Lawyers, members of the legal fraternity, registrars, other officers of this court, court reporters of Live Law and Bar and Bench, students from the various law colleges, and all other distinguished persons present here. Let's all look forward to a great and cerebral discussion. Thank you.
Thank you, sir. I invite Advocate Gauri Balagopal to introduce the Chief Guest, Sri.Gautam Bhatia, Advocate, Supreme Court of India, and the moderators of the session to the august gathering.
I have been bestowed with the pleasant duty to introduce the speakers for the day. It is my distinct honor to stand before you today to introduce a luminary in the realms of law and literature. Sri.Gautam Bhatia, an eminent lawyer, constitutional law scholar, and an accomplished science fiction writer, has carved out a niche for himself in the Indian legal landscape. He embodies a unique blend of intellectual acumen and creative expression. Mr. Bhatia's profound understanding of constitutional law has not only distinguished him, but has positioned him as a trusted authority whose research is sought after by senior lawyers and esteemed scholars. Gautam Bhatia graduated from the National Law School of India, University, Bangalore in 2011, and thereafter went on to pursue Bachelor of Civil Laws and MPhil degrees at the University of Oxford as a Rhodes Scholar. He pursued his LLM from the Yale Law School, specializing in constitutional law. During his time at Oxford, his essays and articles on jurisprudence and political theory was published in leading international law journals and publications. Sri Bhatia had served as a law clerk with Justice Ravindra Bhatt before starting his practice as a lawyer in 2014. He was a pivotal member of the legal teams involved in various landmark cases, including the right to privacy judgment, the Aadhaar constitutionality challenge, and the challenge to Section 377 of the Indian Penal Code. Most recently, he was also part of the legal team involved in the highly sensitive case challenging the abrogation of Article 370 of the Indian Constitution, which is the focal point of our discussion today. His work has been cited by the Honorable Supreme Court on 4 distinct occasions, adding yet another feather to his already vibrant cap. Sri Bhatia has also marked his presence in the realm of legal literature and has published books titled Offend, Shock, or Disturb, which is an authoritative work on free speech, The Transformative Constitution, a radical biography in 9 acts, and The Unsealed Covers, a decade of the Constitution, the courts, and the state. His latest book, published a few months back, titled Horizontal Rights and Institutional Approach, provides a new conceptual model for considering constitutional rights from a comparative perspective. Sri Bhatia has also co-authored a book titled On Citizenship, along with Romila Thapar, N. Ram, and Gautam Patel. Sri Bhatia also regularly writes on Indian constitutional issues on his blog, Indian Constitutional Law and Philosophy, and is also a visiting professor for constitutional law in India's top law schools. Beyond the legal sphere, Sri Bhatia has also ventured into the imaginative world of science fiction through his debut novel titled The Wall, followed by its sequel, The Horizon, both of which featured on Locus Magazine's recommended reading lists in 2021 and 2022. The Wall was a finalist for the 2021 Valley of Words Best Language Novel Prize. Bhatia was longlisted for the astounding award for Best New Writer at both the 2021 and 2022 World Science Fiction Convention. As we delve into the exceptional accomplishments of Gautam Bhatia, it is evident that we stand in the presence of a remarkable individual whose intellect knows no bounds. Next, we have our moderators for the day, Advocate Dr. Jacob P. Alex and Advocate Ramola Nainpalli, who are familiar faces for us. Dr. Jacob P. Alex obtained his LLB from the School of Indian Legal Thought, Mahatma Gandhi University, and completed his LLM from the West Bengal National University of Juridical Sciences and took his doctorate from the Berhampur University, Odisha. Before starting his practice as an advocate, he served as a law clerk and research assistant to Honorable Sri Justice S. Rajendra Babu, the former Chief Justice of India from 2002 to 2004. Recognizing his expertise, the Kerala High Court has appointed him as amicus curiae in several cases so as to provide effective assistance to the court. His report titled Disaster Management Towards a Legal Framework was jointly published by the United Nations Development Programme and the Indian Institute of Public Administration. In addition, he has also conducted extensive research and has prepared reports pertaining to law reforms on various issues for the National Judicial Academy, Ministry of Law and Justice, United Nations Development Programme, and the Kerala Legal Services Authority, to name a few. Advocate Ramola Nainpalli is an alumnus of the National Law School of India, University, Bangalore. She worked as an associate lawyer with Cyril Amarchand Mangaldas, Mumbai from 2014 to 2016 before joining the firm Messrs. Menon & Pai and starting her practice here. In fact, she was 3 years junior to Gautam Bhatia in the National Law School of India, University. Without further ado, let us start the conversation. Thank you.
Good evening to all of you. So the scheme of our conversation, we are planning initially, since the judgment on Article 370 is a very voluminous judgment, we thought of giving you an introduction about the background of Kashmir issue, Supreme Court judgment. Then we will have the conversation. We are planning to concentrate the conversation on three broad issues. After that, Ramola will conclude the conversation by about within half an hour or so, 45 minutes. After that, we'll have an open session where we are free to ask any questions to Gautam. He will answer it. So this is a scheme. So let me give you a very brief introduction about the background of the Kashmir issue. Kashmir was originally a princely state. Between 1925 and 1947, Maharaja Hari Singh was the ruler. On 18th July 1947, British Parliament passed Indian Independence Act of 1947, wherein Section 1(1) say that from August 15, 1947 onwards, the British Empire will be divided into two dominions, that is Dominion of India and Dominion of Pakistan. And by August 15, 1947, the sovereignty of British monarch will lapse and it will revert to the rulers of 562 princely states. And these states were given an option either to join India or the Dominion or Pakistan, or to stay as an independent nation. As per Section 6 of the Indian Independence Act, whoever want to join India will have to execute an instrument of accession. And that instrument of accession essentially provides for three subjects, that is external affairs, communication and defense. As on 1947, August 15th, three states, that is Junagadh, Hyderabad and Jammu and Kashmir, decided not to join either India or Pakistan and they remained independent. Therefore, they did not execute any instrument of accession. But within 2 months, by October 26th, Kashmir faced serious external threat. Then at that point of time, on 26th October 1947, the Maharaja decided to execute instrument of accession with India. And he executed so. Wherein there is a very interesting provision. Paragraph 7, it says that the clause 7 of IOA specifically reserve right of the state of Jammu and Kashmir to enter into agreement with the government of India under any future constitution. So, meanwhile, the Constituent Assembly was debating about on the Constitution of India, framing of the Constitution of India. And there an issue comes about giving special status to Kashmir. And draft article 306A was framed. And this framing of draft article, which gives special provision to Jammu and Kashmir, is having a background. Because at that point of time, war was going on inside Jammu and Kashmir. Then the issue of Kashmir was pending before the United Nations. And thirdly, the legislature or Constituent Assembly for Kashmir could not be established. And unlike Part 3 states, Kashmir, the ruler of Kashmir did not execute a revised instrument of accession, which many other states, including Kerala, are all executed. So in this background, the draft constitution approves that to give a special status to Jammu and Kashmir. Then by January 26, 1950, a constitution was adopted with Article 370, which is titled as a temporary provision. There are two important aspects of Article 370. Article 370 first say Article 238 will not apply. Now Article 238 is it's deleted. Now second, the power of Indian Parliament to make laws for the state of Jammu and Kashmir is dependent on the concurrence or approval of the government of Kashmir. And thirdly, Article 1 and Article 370 was made applicable. Now, Article 1 say India, that is Bharat, will be a union of states. So other than these two articles, other provisions, especially the list items, will be made applicable to Kashmir only if it is approved by the government of the Jammu and Kashmir. Now, Article 370 is having a very interesting clause, Clause 3, which permits the President of India to declare that the article ceases to operate, but upon recommendation of the Constituent Assembly of the Jammu and Kashmir. Then Jammu and Kashmir, by the time November 1956, framed their own constitution. And the preamble of the Jammu and Kashmir constitution, which is given in the paper given to you, it's safe. It is further to define the existing relationship of the state with the Union of India as an integral part thereof. Conspicuously, there is no provision, there is no declaration that Jammu and Kashmir will be a sovereign state. Now, coming back to the present political situation that led to the abrogation of Article 330. On 19th June 2018, the then CM lost support and she resigned. On the next day, invoking Section 92 of the Jammu and Kashmir Constitution, the state was placed under governor's rule. And Section 92 of the Jammu and Kashmir Constitution is having a unique thing because the governor's rule can continue only for a period of 6 months and there is no provision for extension of the governor's rule. Now, by the time that 6 months period was going to elapse, on 21st November 2018, invoking powers under Section 53 of the Jammu and Kashmir Constitution, the assembly was dissolved. Now, after that, on 19th December, exactly on completion of 6 months, 19th December 2018, the President of India, invoking powers under Article 356, imposed President's rule in the state. And the proclamation is very important. Proclamation, two important provisions. One say the President assumed all functions of the government of the state as also all the powers to be exercised by the Governor A. And B, it say declared all powers of the legislature of the state were to be exercised by the Parliament. This is Article 356 1B, which say that upon declaration of an emergency, the President is having an option to empower Parliament to pass legislation on behalf of the state legislature. And on the same day, the proclamation was approved by both houses of the Parliament. Then, after 6 months, this proclamation was extended because Article 356 permits extension of presidential rule. On 5th August 1959, the Constitution application of Jammu and Kashmir Order 2019, that is called Constitution Order 272, which was challenged before the Supreme Court, was issued. Under Article 370 of the Constitution of India, essentially, it superseded the original Constitution Order of 1954 and all modifications which give special provisions applicable to the Jammu and Kashmir. And second, and interestingly, Clause 4 to Article 367 was added, wherein it say that in the original Article 370, the expression, the Constituent Assembly will be substituted for Legislative Assembly. On the same day, Parliament in its capacity as legislature of the state of Jammu and Kashmir recommended President under Article 373 that all clauses of Article 370 shall cease to operate and expressed its views under to accept Jammu and Kashmir Reorganization Bill 2019. On the next day, that is 6th of August 2019, the declaration under Article 373 of the Constitution was issued by the President, that is called Constitutional Order 273, making all provisions of the Constitution of India applicable to Jammu and Kashmir. and declaring that Article 370 ceases to operate with effect from 6/8/2019. After 3 days, Jammu and Kashmir Reorganization Act 2019 was brought into force with effect from 31/10/2019, essentially reorganizing the state of Jammu and Kashmir into 2 union territories. One, Jammu and Kashmir with a legislature, and 2, the union territory of Ladakh without legislature. Thus, the state of Jammu and Kashmir was bifurcated. This issue was taken up before the Supreme Court. In the Supreme Court, this Constitutional Order 272, 273 and the Reorganization Act was challenged. The Supreme Court upheld the, not unanimous, 3 judgments unanimous with Chief Justice and then 2 concurring judgments, but unanimously it upheld all the constitutional actions taken by the Union government. Now, the main points, the main law that declared by the Supreme Court, I'll just point out. One, it said that state of Jammu and Kashmir does not retain any element of sovereignty. Number 2, it say the petitioners did not challenge the issuance of proclamation under section 92 of the Jammu and Kashmir Constitution or imposition of President's rule under 356. Then Parliament under Article 356 can exercise powers of legislature, including law-making powers. This is a very important thing, because there was the argument is this, that when Parliament is exercising special powers during the tenure of emergency, they got a limitation to exercise those powers. Supreme Court said irrevocable decisions can be taken by the Parliament during the tenure of the presidential proclamation. Then it said Article 370 is only a temporary provision. Further said, power of President under Article 373 can be unilaterally exercised even after dissolution of a Constituent Assembly of Jammu and Kashmir, and proviso to Article 370 cease to exist. The President under Article 373 can unilaterally issue notification that Article 370 ceases to exist. To exercise this power, concurrence or collaboration of the state government is not required. Then it said, for bifurcation of states or reducing the area of the state, Article 3 of the Constitution proviso mandates that the views of the state has to be taken. Insofar as Jammu and Kashmir Constitution, there is an amendment which says that it shall have to concur with the views of the state has to be taken. But then Supreme Court said, the views of the Legislative Assembly for reduction of the area of a state is only recommendatory in nature. Then Parliament can validly exercise this power on behalf of the state legislature. Number 8, the Jammu and Kashmir the Reorganization Act was challenged. But learned Solicitor General of India made an undertaking before the Supreme Court that the statehood in J&K will be restored. And recording that undertaking, Supreme Court did not answer that issue whether the state can be divided into union territory. At the same time, Supreme Court upheld the establishment of union territory of Ladakh. This is the brief outline about the background. And this is the law of the land. Now, accepting this, we'll have to discuss about the background of this judgment. Ramola may.
Yes, thank you, sir. So, from this introduction, I think it is fairly clear that several issues were dealt with by the Supreme Court in this judgment. But to focus our discussion, we thought we'd just limit it to 3 main issues. The first is the power that can be exercised under Article 3 as far as reorganization of states are concerned. Second would be if there are any limitations on the exercise of power under Article 356 by the President as well as by the Parliament. And lastly, the unilateral powers that the President can exercise within the constitutional scheme, keeping in mind the federal structure of our nation. So I'll jump into the first issue right away. So just for us to understand, of course, Jacob sir has already given us an overview, but I think it will be helpful for us to hear from Gautam what and how did the Supreme Court treat the exercise of power under Article 3, especially as far as the Jammu and Kashmir Reorganization Act are concerned.
Yeah, is this audible? Yeah, thanks, and thanks for a great summary of the case. It makes life much easier laying it out so clearly. So I think that with respect to Article 3, the core issue was that does Parliament have the power to downgrade a state into a union territory or into one or more union territories? And the main argument from the petitioners was that, two arguments. One, that the text of Article 3 does deal with a range of situations with respect to breaking up a state into one or more states, adding territories, altering the name of the state. But even if you read state as union territory, as article itself says, you don't find any express power to downgrade from state to UT. And the second argument was that there is an implied limitation under Article 3, that insofar as you can read Article 3 in two ways, one that allows for this power and one that does not allow for it, you should read it in the second way, because that is more consistent with the federal structure, and we can go into that in a little more detail if you want to. So those were the two main arguments, and the Supreme Court finally did not answer the question, because as you rightly said, there was an assurance made by the Solicitor General that statehood would be restored in due course. So ultimately the court did not answer the question with respect to the scope of the powers under Article 3 that Parliament has for this purpose.
So as Jacob sir had said, and the question was left open on what the powers are, the limits of that power. But in the same breath, they have upheld the creation of the Union Territory of Ladakh, which if you look from a geographical point of view, I think is more than half of the original state. So even though the question has been left open, a part of what that legislation does has been upheld without discussion. So does this, in essence, foreclose any kind of discussion on the validity of that power?
Yeah, so that's a great question, and I'll answer it in two ways. So first, just to put the council hat back on, there was no dispute between the two sides that the power that the Parliament does have includes the power to divide an existing state into another state plus a UT. And because one is that that flows from the text of Article 3A. So when you say that Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of states, and when you read state as UT as you are required to do, then that is very clear. So that was.
What about explanation 1?
Yeah.
Explanation 1, which says that state includes union territory.
No, exactly. So when you read union territory as
A
part of state, then that is very clear that what Parliament can do is to divide an existing state into another state plus a UT. So that wasn't in dispute between the two sides. The Ladakh bit was not in dispute. And brings you to my second point, which actually goes a little deeper into the issue. So the reason why that wasn't in dispute, even as a matter of principle, takes us back to the question of why does Article 3 give Parliament these far-reaching powers in a federal structure, right? So why does Article 3 not give the state legislature a veto over its own division, and why is the power only of a consultation? So under Article 3, if Parliament wishes to alter a state boundary or add or detract from a state territory, the only requirement is consultation with the legislature.
But that is how we have divided many states.
Yeah, so the reason for that is interesting. And if you go back into the debates, the framing debates, this was actually in discussion. And the reason why it was limited to consultation was because what the framers understood.
No, consultation or views.
Or views, yeah.
Correct.
So what the framers understood was that the structure of the states that we inherited at independence was non-homogeneous. So states were not uniform territories, and often within a specific state, you would have further linguistic, cultural, ethnic minorities who would then want their own, territory, their own autonomy. And our history has instances where this happened, right? And so, if you gave the existing states the power to veto these demands, then that would effectively mean that within the state, majorities would oppress minorities.
Correct.
And so, Parliament was given the final power on this with a consultation requirement. So, the idea was to protect minorities within the state, and if they want their own future state within the union, then they can have that. So, that's why the power of Parliament was of this kind. And that's why if you are dividing a state into a state plus a UT, where you're carving out one
UT.
Yeah, you're carving out the UT and then setting them on the path to eventual statehood, then that's well within the overall vision of Article 3. But that is not the same as converting a state or changing its character altogether. So that was the argument was more on that. And so that's why on the issue of Ladakh there was no dispute. And the court, that's why there's no discussion also.
I think that makes a lot of sense. So what you said about UTs eventually being state, so the essential difference being the autonomy that probably a state exercises within its territory. Now, you touched upon why Article 3 is as it is, probably to protect minorities within the state, but is completely disregarding or giving absolutely no effect to the views of the state in a matter where its own territory, which is integral, is varied. Does that subvert in any manner the federal structure of our constitution, which is also part of the basic structure? So is the constitution itself taking away from the federal structure by having an article in this fashion?
Yeah, so I think that there are two or three answers there. So one, of course, is the constitutional structure itself, and in that sense, as many cases have held, we are not a federation in the US style, where every state has its own constitution. Of course, J&K had it, and that's another point of discussion. So where state boundaries are inviolable. So that was not the choice that was made, and for a number of reasons that included, for example, the requirement of a national political economy at the time of independence, the need to present a uniform face of India in international affairs, and fears of secession. The constitutional structure is skewed towards the center. The question, and Article 3 is one of the many provisions that reflects that skew towards the center. You have it in the fiscal provisions, you have it in the incompetence, all of that.
The 356.
Sorry?
356.
Yeah, of course, 356 as well, right? So, but the question, as you rightly said, is that then the debate then is about the limits of that skew. And the real core debate in the Article 3 point in the Article 370 case was that are there some limits to that power under Article 3? And the argument the petitioners made was that the powers are limited at the point at which exercising the power would undermine the federal structure. So that was the core argument, because if the parliament is allowed to completely degrade a state to a UT, if that power exists, then conceptually the power exists for all states. And so therefore the power's width is one that would allow for converting all states to UTs. But Article 1 says union of states, not union of UTs. That was in effect the core argument, that power cannot therefore be in Article 3. Which was not answered. That question wasn't answered.
So I think just one last follow-up question on this issue. As in the introduction it was said, this question was not gone into on the basis of an undertaking which was given by the Solicitor General. Just for us to understand, are these undertakings binding on governments? Because tomorrow the government might change. Are they bound by this undertaking? And there was also a subsequent direction to conduct elections. In this, the undertaking was that statehood would be restored. There was also a direction to the Election Commission to conduct elections before, I think, September of this year. So how would, say, a citizen of Jammu and Kashmir enforce such a provision?
Yeah, so I think on the first question, the restoration of statehood can take place only through the repeal of the Reorganization Act, which is of course something Parliament has to do. And the Solicitor General's undertaking can bind the executive, but not Parliament. Now, of course, in the Indian...
Gautam, here, pause for a moment.
Yeah.
The abrogation of this Jammu and Kashmir Reconstitution Act, suppose a statehood is restored, the Assembly can do it, no?
Sorry?
The Assembly can do it because...
No, because in the schedule of the Constitution, all of that, we have to amend that, right? So the Assembly cannot give itself statehood. As of now, under the 2019 Act, it's a UT. So only after that Act goes can the Assembly do any or take any action, because its powers flow from that Act. So the Assembly cannot go above the Act that creates it, effectively, whenever the Assembly is restored. So that has to be by Parliament. And the Solicitor General's undertaking can bind the executive, but it can't bind Parliament. So I think one unanswered question then is that who should the undertaking have been taken from in this case? Now, of course, in the Indian system, we have a parliamentary system where you have a lot of fusion between the executive and Parliament, and with various constitutional amendments like the 10th schedule, actually effectively in the Indian constitutional system, the executive is quite dominant over Parliament, but still there is a formal separation. So I think that one question then is that can the executive's law officer actually bind Parliament? I think that's something that is unanswered. And yeah, I think as far as the undertaking on the elections go, so the holding goes, so I think that the Supreme Court obviously does have the power to pass directions, and if insofar as the election commission then say does not conduct elections under the time stipulated, then theoretically one should be able to file a contempt application against the body based on the judgment, but then we have to see how that goes. So I think but that's still, I think, quite far in the future, so we'll have to see.
The Act will need to be repealed first and then it goes into elections like that?
Well, not necessarily, because the Act itself makes provision for UT elections. So the time limit is only for elections. The time limit is not for restoration of statehood. So technically you can have elections for the UT's assembly. You don't have to restore statehood for that to happen.
Okay.
Now I think we can move to 356.
Yeah, we can move to the next.
Yes. See, coming to 356, it's a very unique power as far as a federation is concerned. The moment we say that India is a federation or a quasi-federation, whatever, then no power similar to 356 can be found in any other constitution for that matter. Now the most important and provision is, I would say 356(1)(b), which says the president, upon declaration of presidential rule, declare that the powers of the legislature of the state shall be exercisable by or under authority of the parliament. Because 356 route was adopted by the parliament in the instant case to validate the abrogation of 370 or whatever. So how you place the whole thing in the context of 356 specifically say that if the president by proclamation declares that all powers of the legislature will automatically be exercised by the parliament, and per se you can't say it is unconstitutional, because it's not undemocratic also, because people are elected to the parliament by the people from the state also, they are also there. So why can't the parliament take a decision on behalf of the state?
Yeah, so I think actually it's interesting, the US constitution has actually a somewhat similar provision, but they've never used it. There was once there was a rebellion way back in the 19th century, there was some talk of using it, but they've never used it. Of course, in our case, it's been used a lot more. So I think, so there were many things that were not in dispute in the case. So of course, one thing not in dispute is that under the 356 proclamation, as you rightly said, Parliament steps in for the state assembly. But as with the Article 3 argument, I think this is what makes this case particularly interesting, because none of the arguments were basically straightforward. They were all, based on constitutional principle. It wasn't something that could get directly from the text. This was also an implied limitations argument, essentially. So I'll try and break down the argument in simple terms. So the argument was that, look, ultimately the extent of the power you have under 356, as with all constitutional powers, must be understood in the context of the purpose of this provision. And the purpose of the provision flows from Article 356 Clause 1, which is that if the President, on receipt of a report from the Governor of a state or otherwise, is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, then he may do X, Y, or Z. So the idea underlying 356 is that things have broken down in a state to the extent where governance is no longer possible in accordance with the provisions of this constitution. It could be internal rebellion, could be complete disorder, could be many other things. And so therefore, the national authority, the federal authority, must step in and take over governance until such time that you can restore the compliance with the constitutional machinery. And so therefore, the task of the Parliament and the President when acting in as substitutes of the state authorities is what the petitioners called restorative, which is that you restore status quo ante, how it was before you had to declare a 356 proclamation. And so therefore it follows, and again just to paraphrase the argument, much as 356 empowers you to do some things for X purpose, it also therefore limits you only to accomplishing that purpose. Right? And so if the purpose is restorative, what you can't do then is make fundamental structural alterations that completely change the structure of the state itself.
Irreversible changes cannot be made.
Well, so I think the irreversible point is interesting because the code goes into that. So we can talk a bit about that.
Yeah. So as far as irreversible point, see, the argument is this: once the proclamation of emergency is there, the Parliament cannot make certain decisions which cannot be reversed subsequently. Say, for example, that happened in state of Jammu and Kashmir. The decision to divide the state is an irreversible decision. So such decisions cannot be taken. Now, the background, but Bombay case actually permits you, once you obtain approval of the Parliament, you can go to that extent. That is what the law says.
Yeah, so I think this is a really interesting point, and this is where you see, I think, a tension in the majority judgment of the court in 370. So when you use the word irreversible, right, irreversible can mean one of two things. One is a simple, say, physical irreversibility. So I build a dike to stop a flood. There's a flood happening. I build dikes to stop the flood, or I demolish some things. So there is a kind of physical irreversibility where you can't undo something you have changed like permanently in that sense. So that's one kind of irreversibility. The other kind of irreversibility is constitutional irreversibility, right? Which is that, so for example, and to take this case, if you alter the status of a state to a UT, now when you bring back the assembly, that assembly cannot reverse that because they're now UT, so they now have less powers. So basically you have given them less powers than they had, so they can't reverse that particular change. And so that distinction between the two kinds of irreversibility is the key issue there.
Law-making and non-law-making powers.
Well, but the kind of change you're making, right? So exercising your law-making powers, the kind of change you're making. And there are two things I think to look at, right? So one is 357 clause 2. I think it's perhaps not here. So 357 clause 2 says that...
Sorry, it is not in the paper.
I'll read it out, So it's because it's a very interesting provision, and there's a history which I think is key to this whole understanding of 356. So any law made in exercise of the power of the legislature of the state by Parliament or President under 356 proclamation shall, after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature or other authority. Right? So now the interesting thing is actually that before the 42nd amendment, the emergency amendment, it was different. It was automatically ceased.
Automatically ceased after
Unless
6 months.
continued, yeah. And then it was changed by Indira Gandhi during the emergency, and then the 44th amendment did not change it back. So one of those undone changes post-emergency. So the argument then was that 357 clause 2 still presumes that when that competent legislature returns, it can, at least in theory, reverse that change if it so wants. But if it's now a UT, it can't do that, right? So it is unable to do that as a constitutional matter.
But then the situation is different because it got stamp of approval from the parliament.
Yeah, so that's exactly where the issue of implied limitations comes in, right? So does 357 and 356 place an implied limitation upon parliament to not make those kinds of changes that are fundamentally non-restorative in nature, which can't be, restored? That was the argument. And I think here the judgment is interesting because, of course, the judgment says that irreversible changes can be made. So the majority judgment says that, and that, as we have seen, that's quite correct. There's no dispute there. The judgment does not deal with this distinction between kinds of irreversibility, but what it says following Bommai is that there must be a nexus between the kind of change that you are making and the proclamation's purpose. Right? So it says that. Now, in this case, it doesn't deal with that question whether it was or wasn't, but it then follows that if a proclamation's purpose can only be restorative under 356, because that is its purpose, it has to be, it can't be beyond that, then any power that goes beyond that doesn't have a rational nexus with the restorative goal. So then the question is that does the judgment actually then place certain limits on 356 by saying that one, there must be a nexus between the proclamation's goal and the actions you take as parliament, and two, the court can review that under the Bommai standard, right?
Yeah.
So then the question is that has the court endorsed a kind of limitation on 356 powers,
Yes.
which we will find out next time this comes to court. Right?
Maybe that is one way of looking at things.
Yeah.
And one more interesting.
Yeah.
Somewhere I have heard, but hearing the arguments of solicitor,
Yes.
that the same situation was there during the formation, reorganization of state of Punjab.
Yes. Yeah.
That was also during an emergency.
Yeah.
And there also this argument was raised.
Yeah. So there was a High Court judgment.
High Court judgment,
Yeah.
Khanna.
Yeah, by the older Justice HR
Khanna.
Yeah, so that point was made, and there was an issue. There was that issue between the two sides, and the petitioners argued that was incorrectly decided. It should be overruled. And in any case, that wasn't applicable to this case. And the state argued that should be applied. And I think that finally the judgment of the court, the majority, by saying that Bommai's requirement, there must be a nexus between the proclamation's goal and the action, effectively makes that High Court judgment now sort of old law. So the standard now that we all follow is Bommai. And the question then is that under that standard, is it or is it not allowed? I think that is the open question.
But the general apprehension about this judgment, some people are saying that tomorrow any state can be placed under emergency in the same fashion, and as Parliament can assume the role of the legislature and can give the views and then divide the state. So this is one apprehension, one main criticism of the judgment. How you take this? Because
so I think that is exactly the question of how you read the judgment, right? And I think that will exactly be the future legal battle will exactly be on that. So if that happens, if say this happens in the future at some point, what the apprehension is, then of course the state will argue that the Article 370 judgment, by allowing for irreversible changes to be made, sanctions this kind of an action to take place. On the other hand, those challenging it will argue that this action, dividing the state, can never have a rational nexus with the proclamation of the 356, because the whole point of 356 is to restore to what it was. So I think that will be the key battle in the future if it happens. And I think that the interesting thing about this judgment is that, again, much like Article 3, it can be read both ways.
Yeah.
So,
Another way of reading is very interesting also. That also I find a very interesting argument, which says that look, there are not many powers in the parliament and the constitution, which if you are not controlled, it can create a lot of confusion.
Yeah.
356, every now and then if you are going to technically saying that power is there.
Yeah.
The question is whether you are going to exercise it quite frequently. Now that depends on your restraint, you are using it, and this is one judgment which is very special to Kashmir situation.
Yeah.
And it may not happen in the other situation.
Yeah, but I think the key there, and you raise a very interesting point, is that, and this is the big debate between political constitutionalists and legal constitutionalists, right? So the political constitutionalists will argue that the restraints have to come from politics, right? So if tomorrow the center wants to do this to another state, they should be concerned that doing this will, lead to a political backlash which will harm them, harm their governance, or it will harm them in the next election. Whereas the legal constitutionalists would say that the court must enforce those safeguards. It can't be left to politics. I think the really interesting thing is that where you have constitutional silences, much like in 356, Article 3, that becomes a big debate, right? So should it be something that was the idea of the framers? Ultimately, these silences are meant to be resolved through political back and forth, or should the court be the body that enforces those guardrails, those safeguards? That is an ongoing, debate, and that I think will continue on in the future.
Yeah. What about?
I think we'll just move on to the next.
That's why
we're
time
running
is
slightly short on time.
Yeah.
As in the introduction, we touched upon the various levels of consultation, approval, etc. that's required from the state government, or the state of Jammu and Kashmir in particular, while the president exercises power under Article 370. So I think it can be a little difficult or confusing for us to understand. So could you just take us through 370 and how it is that the court concluded that the president has in effect unilateral power under that?
Yeah, so 370 is a very unique provision, right? So that it created this very complex relationship between the union and the state of J&K. And so, I mean, the entire thing is a little complex, so I won't go into the whole, article, but just come to Article 370, Clause 1, Subclause D, right? So, if you read it sort of, from the beginning, notwithstanding anything in this constitution that is there, and then such of the other provisions, that is, provisions not being Article 1 and 370, because those two were applicable to J&K from the beginning. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Then go to the second proviso, provided further that no such order which relates to matters other than shall be referred to in the last preceding proviso, which is certain matters in the instrument of accession, we don't have to go into that, shall be issued except with the concurrence of that government. So what basically this meant was that in the beginning, 1950, there were two constitutional articles applicable to Jammu and Kashmir. Article 1, Article 370. The rest of the Indian constitution, for it to be applied to J&K, would require a presidential order with the concurrence of the government of J&K. Now, over the years, bit by bit, many provisions of the Indian constitution, in fact almost all, were applied to J&K using this process. So, there would be a presidential order of 1954, the famous one, 65 and so on, where it would be like using this order, articles like 5 to 12, articles 17 to 25, just taking random numbers, now are applicable to J&K with a few modifications here and there. So that was how the Indian constitution would apply to J&K. Article 370 clause 3 said that if insofar as you want to abrogate 370 or abolish or alter 370 itself, then the president can do that through an order, provided that the recommendation of the Constituent Assembly of the state would have to come, would be necessary for that to happen. Now, the reason why this became controversial was that the J&K Constituent Assembly sat from 1951 to 56. It enacted the J&K Constitution, whose preamble is there in this document, and then it made no recommendation. So it was supposed to at that point say, okay, now we recommend that this will be what Article 370 will look like, or abolish it, or whatever. They just dissolved themselves or adjourned sine die without making a recommendation. And so the issue was that you had this, so 370 said that to abolish 370, you would need a recommendation from the Constituent Assembly, but there was no longer a Constituent Assembly. Right? So what do you do? That was the key issue.
No, I think I'll just add on to that. This is what the Supreme Court have actually addressed on this issue. Say that now to get a concurrence or recommendation of the Constituent Assembly is a near impossibility, because Assembly is not there. It was, it was over 1956 onwards. There is no Constituent Assembly. So therefore, Supreme Court said that provision, that proviso, is an impossibility, and this is perhaps the only provision in the Constitution which say that it will cease to have effect upon issuance of a proclamation notification by the President. So therefore, they just took 373 and declared that the proviso is no more relevant. So that is the route they have taken.
But you had said that there are several constitutional orders that have been passed by the President in exercise of powers, both under 371D and now most recently under 373. Obviously, the purpose of these orders is towards making the state of Jammu and Kashmir as much as any other state in the country. Now, the goal of the Constitution at the time of its inception was national integration, as you had mentioned at the beginning, to put out a united front and all of that. So, in this context, regardless of what led eventually to whether the proviso applies or not, is it not in national as well as administrative interest to take away the special status and make Jammu and Kashmir
an integral part of India. Integral part of India.
Integral, which does not say does not have to govern itself with another constitution, because every application under this would require an amendment in the Jammu and Kashmir Constitution. So would it just not be better in national interest for this status to be taken away?
So this was actually I think the unstated debate was actually this, which is what does integration mean, and what is the constitutional vision with respect to what integration means. So if you look at the arguments made by the Attorney General, and the arguments made by Mr. Salve, so they argued that look, the ultimate goal was that you would have a sort of one-size-fits-all approach to federalism, where every state has a similar relationship with the center. That was the ultimate goal of 370, using this method of presidential orders with the concurrence of the government. And so therefore, and effectively, and this of course everyone agrees on, by 2019 it was more or less done. There was no real, well, there was something still left, but a lot of it had now been subsumed using this method. And so they argued that look, this is just the logical final step of that process. So that was the argument made by the state, or by at least two councils on the side of the state. On the other side, the argument was, and I think this wasn't really made expressly, so you wouldn't see it in the oral arguments, but the underlying idea was that there is this idea of asymmetric federalism, which is that in a constitutionally diverse or plural country, you have different relationships that govern different units of the federation vis-a-vis the center. So if you look at Article 371, for example, you see that in many of the northeastern states, specifically Mizoram and Nagaland, there are, for example, exemptions from the application of certain laws without concurrence from the assembly of those states, involving personal laws and so on. And if you look at the history of how that happened, it was through social movements, through protests often through violence. So Nagaland, you had long-running insurgency, and Article 371 was an attempt to contain that insurgency by extending certain kinds of asymmetrical benefits. That was the argument.
It's like political compromise.
Well, exactly, right. So that I think, and you really, I think that's the key. That's the key point you've made, because, and this is sort of now the analyst hat on, taking a step back from the case. In some nation states, there is a kind of normative or principled commitment to the idea that you must have asymmetric federalism. So, for example, Canada, Quebec, linguistically different. In Belgium, Flanders, and the rest of Belgium. So, in some countries, there is that idea that okay, there is a principled reason why we have these differential arrangements. In some countries, it's a political compromise where, as and when difficulties arise, you address them through these compromises. And in the Indian case, it is more historically it's been more a political compromise than a principled commitment, right? I think so, and I think that actually ultimately, if you want to understand why the judgment went the way it did, I think ultimately it's the fact that the Indian Constitution, in the Indian Constitution, this asymmetry has always been a political compromise. And so therefore, if it is a compromise, it can be ended also, in a similar way. So there is no constitutional reason to entrench that.
That is why, without any concurrence of the parliament to abrogate this provision, the president was given the power.
Yeah, which is something that would not have been possible had the court, believed that there was a principled commitment to that asymmetry and not a political one. So I think that ultimately the judgment's key lies in this
matter.
Yeah.
What would be the alternative? Okay, if suppose the court did not hold, but in the interest of national integration, what would you suggest would be the method to achieve the same end?
Same result.
Yeah, if not through 373, what would be your, how do you think the same end could be achieved?
Yeah, so I think that in this case, so we had many discussions on various possibilities, and I think that if you want to maintain fidelity to sort of the structure of 370 purely as an interpretive matter, there would need to be a resuscitation of the Constituent Assembly of J&K, which is a political device, which would then approve that to happen.
That's only a theoretical possibility. Practically, it could not.
Well, not right now, and obviously not right now. But in countries across the world, you've had that happen. Good Friday Agreement in Ireland. So oftentimes conflict has been brought to an end through.
But our experience is different. You take any provision, reservation,
it may not be feasible right now.
So we'll have to take some route. Well, let us move to the last question, and by the time we round up this session, then we'll go for public. So one last question, all constitutional issues are political, including this. So when normally we find that when Supreme Court is faced to address the issues regarding personal liberty or fundamental rights or human rights, will go for a very vast, liberal interpretation. But when it comes to interstate dispute or formation of state having some external, affairs issues, then it will take a very different stand. So how in the broader canvas you see these political issues when confronted with the Supreme Court, what is the basic approach? Because whether that is having any bearing on this judgment, that is what we want to find out.
Yeah, I think that's a great question, and this is actually what I'm working on right now as in a book project. It's what I call the centralizing drift. So my argument is that that over the years, the Supreme Court's approach to constitutional structure and constitutional design is broadly a centralizing drift, which is that where there is an interpretive gap, interpretive silence in the Constitution, the court resolves that broadly in a way that entrenches the centralizing tendency in the Constitution. There are some exceptions to that. Bommai is one example of that, which is a partial exception to that. But broadly, that's been the trend from the first really major federal case, which was State of West Bengal versus Union of India, the Mines case, which the court really got into the theory of it. From then to now, the court has broadly been of that view, and I think that to deepen that point a bit, it's not necessarily something that you could say, okay, the court is doing it, but the constitution itself is in a certain sense has a centralizing drift to it, which is there in many provisions.
Many provisions.
And there are reasons for that, going back to independence.
No, national security.
They may not be reasons now, but there were reasons at least back then. So, so I'd say that would be how I'd sum it up. So there is a centralizing drift in the court's understanding of constitutional structure, which comes through in a case like this and in other cases, with a few counterexamples, but mostly I think it's that.
Ramola, you can conclude, then we'll go for questions.
We've been most lucky to have your perspectives, not only from what was argued and what is in the judgment, but also from what actually happened in the courtrooms.
Point of view. Yes.
Yeah, and given your constitutional experience, you've been able to draw on so many other aspects as well. So we're very grateful for that. I think now I would just open the floor for questions, because I'm sure a lot of us have a lot of questions.
So whoever want to ask questions, just raise hands. Our volunteers will come and give you the mic. And you can introduce yourself and just Ajit Joy sir. Ajit Joy sir. Yeah.
My name is Ajit Joy. Thank you for your talk, Mr. Gautam. This relates to something that you referred to in your presentation, that is the relationship between political contestation and constitutional contestation. Ultimately, most political questions land up in the court. What happened in the Kashmir one is that it kept pending for a long time. There was kind of judicial abnegation. And after 4 years, it was like a fait accompli. Of course, we can say it's national interest, but it was more like a fait accompli that the decision would go this way. Same with the Ayodhya matter. There also went, and it's surprising that all these decisions are unanimous. Nobody sort of has another view. I don't know why. My question to you is this some kind of a transformative constitutionalism or a transformative constitution, the usage of our constitution that we see, in this era where the majority political view somehow also becomes the view of the court?
Yeah, thank you for that question. So I think there are two things there. One is that there is this interesting literature on the issue of judicial delays. So judicial delays can, and I mean not the backlog, but delay in adjudicating these kinds of cases. So of course one kind of delay is evading deciding a case. The other kind of delay sometimes is that to take the political sting out of an immediate situation. You delay for a while until there is an atmosphere in which you can decide the case actually in a legal way, where the political pressures are a little less. So, I mean, it's an open question where you see delays in the Indian context falling. So at least in some contexts, like I think, for example, like demonetization, it was clearly, a situation where if you delay beyond a point, it is effectively infructuous. It wasn't the question of taking the sting out of the case. Whereas something like 370, you might say that, the court actually has to wait a little while at least before it can decide the case in a way that can be done without the political atmosphere being so febrile. So I think that's something that you see on a case-by-case basis. As far as the majoritarian bit goes, I think that if you look at the history of courts, across the world, so I think that what you often find is that, and these are of course courts that are tasked with deciding political cases and cases that have deep political ramifications, that often the courts are not in a position to be in a perpetual confrontation mode, with the political executive and the legislature, because as was said in the Federalist Papers, the courts have neither the sword nor the purse, right? So I think that you will see that this is something that's there across the world, where the space that courts have to act in is inversely proportional to the strength or the dominance of the political executive. And of course, the key question is how the courts navigate that space, which is what is often the interesting part.
Sir, good evening. I am Aslam from Perimbaur, currently studying 3-year LLB, Sri Narayana Law College. I endorse the judgment which upheld by Supreme Court of India as abrogation of Article 370. But some concerned problems does not understood yet. Many democratic problems are faced Jammu Kashmir yet now. I written some questions. The restored state still alive presidential rule. Why they are not declare any election and elective members? One. And second question, many of the civilians killed in Jammu and Kashmir, which is something around in accident claims lives of human being regarding a state. And the third question, electricity power disconnection and internet shutdown, the major issue faces the Jammu and Kashmir people yet now. How many undemocratic problems can find if we remind sometimes report regarding Jammu and Kashmir? Which functionaries who would rely upon this question answer us? And who can answer it, the problems in faced people of Jammu and Kashmir? Thank you.
So as far as the internet shutdown goes, there was a separate case that was on that. It was Anuradha Bhasin versus Union of India, where the court said that the internet shutdown cannot be permanent, but then it delegated that task of determining the proportionality of it to an executive formed committee. So that was a case that went on for a while and ultimately did not really yield, I think, a specific outcome in terms of an enforceable order. But you can read that judgment. It discusses the whole internet shutdown issue. As far as elections goes, so the question was put to the Solicitor General in court by the Chief Justice when this Article 3 issue was being argued. And the state's position was that the climate is not possible right now to hold elections. And so then the court has said that it has to be done by September of this coming year. But as Ramola said, we have to see if that's enforceable, and I think we'll find out in due course if that's enforceable or not.
There was also Justice Kaul's concurring judgment which proposed the setting up of a truth commission. So I think to address the concerns of the historical injustices, and like you asked, if what can the people do, I suppose if the truth commission does eventually materialize, it probably may address some of these concerns.
Yeah, but I think, but just to be a little careful on that, because it's a very South African model, and transplants sometimes don't work unless you pay a little attention to how it's done. So I think that the idea is obviously and always a good one, but the specific term TRC has very specific connotations. So I'm not sure how well that may translate. And in South Africa right now, it's very controversial. Many of them say, it was all wrong and shouldn't have been done. So I don't know how the transplant would work.
No, that Boy has asked one more question that you are not answered. That's somebody, more people were killed, and some inhuman
political violence.
Political violence are going on. That's you are not answered. No.
Yeah, I don't think I have the competence to answer that. If I had, then
Gautam, you are speaking about this possible centralizing rift, going back to central. But let me ask this question. Ever since our constitution was in force.
Sorry, which one?
Ever since our constitution came into effect, up to ADM Jabalpur, it was absolutely the same. Only difference was at that time we didn't have any other political parties. It was basically Congress everywhere, and therefore we didn't have the kind of debates today which we are having. But what happened before 1977 and what is probably happening now is probably the same. That's an observation that I have. And if you do that comparison, wouldn't you think we are going back probably the same era that we were living from 1950 to 1977?
Well, I think the difference in terms of at least what you said is that it is a multi-party system, at least at this point of time. And there are of course multiple state parties. So I think that in that sense there's a distinction. But I think that you're obviously right in that there was a period of time when there were coalition governments at the center for a very long time, and that time seems to have ended, and so we are going back in a certain sense to a time of a single party dominance at the center. I think that you're right in that that was a defining feature of that initial period, and actually and there is this interesting thing where some of the court's federalism protecting judgments have actually come during coalition eras, and its more centralizing judgments have come, during single party eras. So I think there's a little interesting correlation over there. So we'll see, I think, how it goes in the future. Yeah.
What I'm more worried is the judgments on personal liberty that's being taken away. We have bail applications, Gautam Navalka, and followed by that. So that is exactly where, more than 370 and our concerns about the majority government and what they could do. I still remember when ADM Jabalpur was going, the first question from HR Khanna, when we are speaking about Article 21, we are not just speaking about liberty, but we are speaking about life. What would you do without battling an eyelid? He said, yes, even if it includes life, yes, the government has a right to do whatever it wants. So when it comes to personal liberty now, I believe the courts are probably taking a stand with the government and against liberty.
Yeah, I think that you'll see two strands of judgments coming out, which I think shows that the Constitution is sort of always a terrain of contestation. So with respect to your bail cases, you have one strand of judgments that do two things. One is that they interpret the terms of the UAPA strictly. The threshold for the offense is high, and therefore to establish prima facie case is therefore more difficult. And two is that they refuse to fill in the gaps in the prosecution's version with inferences of conspiracy. And so once you do those two things, then often the prima facie case falls apart, and then bail can be granted under 43d5. Whereas you have another strand of judgments that one reads the offenses, substantive offenses, in a lower, more expansive way, and two does fill in the gaps with inferences, and thereby then denies bail. So I think you have both kinds of judgments at every level, from trial courts up to the Supreme Court. I think the only answer is to advocate for, the more liberty-oriented reading before the courts, because there are judgments which endorse that view, and there always have been. So I think that's sort of what I would say would be the thing to do.
Something like critical legal studies movement which say that law is nothing but politics.
Well, so I think that the law is always influenced and informed by politics, but I don't think it's reducible to politics unless you have
Right.
Sorry?
Absolutely right.
Yeah.
Sir, good evening, sir. My name is Aditya and I'm a law student. My question was regarding the fact that the Supreme Court chose not to answer with regards to the Article 3 and how it was applied. So obviously this was not a natural application where you're completely changing the character of a state and dividing into two union territories, and that was a point of contention and the court chose not to answer it. So my question was it right on part of the Supreme Court to do that? Because one, the whole process was challenged from Article 370, and of course passing this legislation, the Reorganization Act, and converting it into two union territories was a consequential process. So why that was carried out? What was the logical rationale behind it? Because the entire argument from the other side was that we are doing this because it's a natural step that needs to be taken, and Jammu and Kashmir needs to be integrated with the rest of the country. However, since the judgment has been passed, we can't say that Jammu and Kashmir has been treated like other states, because it's still been put into indefinite lockdowns and the internet issues and the fact that it's no longer a state, and what is the justification or the purpose of doing that. The Supreme Court chose not to go into it despite acknowledging that there was a change of character. So wasn't this a question of importance, and the fact that Supreme Court chose not to answer it, isn't it going against the fact that even if something is passed by a parliament through a democratic process, the Supreme Court, when it looks into such matters, has the right to question it if it feels that it's not a very rational application or there could be an intent to deceive? Although it's not the question that there could have been an intent to deceive, but not looking into this matter completely, was that a right thing for the Supreme Court to do?
Yeah, so legislation cannot be challenged on grounds of irrationality, right? So only executive action can be. Whereas because legislation is the product, or at least in theory in a parliamentary system, is meant to be the product of deliberation among multiple members and is primary in character. So you can't challenge legislation on the basis that it was irrational. In some countries, you can challenge the process of legislation, or say insufficient deliberation, or say clearly if papers were not served on the parliamentarians. So but that wasn't the case. That wasn't challenged in this case. The only thing you can challenge on legislation on grounds of is absence of power. Either you don't have the power to violate fundamental rights, or don't have the competence to pass that law. And therefore, the key challenge actually was that regardless of the motivations of Parliament, because that's something the court can't go into, regardless of the status, or say the situation in J&K at the time, the Constitution denies to Parliament the power to do this at all. So that was basically the argument, which the court has left open. But the court could not have gone into the rationality of the law, or whether it was the right thing to do or the wrong thing, because the court doesn't have the institutional wherewithal or the legitimacy to answer that question. That's something that only Parliament can answer. But the question of power was the issue that was before the court.
In Article 370, we see two terminologies used, one being consultation and the other being concurrence. And I may be wrong, but I understand that consultation is used in the context of areas already covered by the instrument of accession, because it's already done. Whereas for other matters where integration with the Indian Constitution is to be done, that requires concurrence. So seen in that context, the Supreme Court also did pose a question whether Jammu and Kashmir retained any element of sovereignty, and that was answered in the negative. But one of the key aspects which was relied on to answer it in the negative was to rely on a proclamation by the Raja. So the Apex Court said that in this proclamation, which is just preceding the Constituent Assembly of Jammu and Kashmir presenting the Constitution there, there was a phrase used in the proclamation which said that for matters for which the Constitution of India would be applicable, the Indian Constitution would prevail. And that was taken to be the Constituent Assembly, or Jammu and Kashmir rather, accepting or giving up its sovereignty to that of India. Do you see a jump? This is my question that I would like to pose on that. Is there a jump in the logical analysis of the Apex Court there? Because the terminology used is, of course, I cannot paraphrase, I cannot quote it now, but for the areas to which it applies, and that is a vague terminology. Can we assume that there is a giving up of sovereignty there?
Yeah, so I think that the sovereignty question was quite a red herring in this case. I don't think anything turned on that. Because the entire arguments on both sides were conducted within the scope of the Indian Constitution. And the argument was that ultimately the Constitution prescribes a certain way to do the action that has been taken by the Union, and that way was not followed. That was the core argument, stripping aside all the complexities. So in that sense, the question of sovereignty did not, in my view, really arise at all, and was quite a red herring. So I think the answer, if there had to be an answer, actually is in Article 370, right? Because the moment that Article 370 says that Article 1 applies to Jammu and Kashmir, and Article 1 says that India, that is Bharat, shall be a union of states, then that sovereignty question at that point is at least as a constitutional matter, is answered. Now, there may be political debates about what constitutes political sovereignty and all of that, and those are different debates. But in the context of this case, where the arguments were in the contours of the Indian Constitution, in my view, it was answered there. So I'm not quite sure why the court needed to go into that. For me, it wasn't required to answer the questions before it.
Article 370, clause 3 says, before annulling or abrogating the provision, the recommendation of the Constituent Assembly must be sought. Supreme Court has come to the conclusion that is now an impossibility. When the Constitution was drafted, Constituent Assembly of the Jammu Kashmir was there. Legislative Assembly of the Jammu Kashmir, as far as I understand, came into office only after 1956. I am not sure, you can correct me if I am wrong. So when our constitution was drafted, they has chosen to include the Constituent Assembly of the Jammu Kashmir, whose recommendation must be sought. Legislative Assembly of Jammu Kashmir succeeded the Constituent Assembly of the Jammu Kashmir. So, relying on Article 368, which confer power on the Parliament, the very same body, the constituent power to amend the Constitution, though the body is same, the power that is being exercised by the Parliament under 368 is entirely different. They are exercising. So that applying that analogy, was not the Supreme Court could have, or at least the Supreme Court could have adopted the same principle and has come to a conclusion. Legislative Assembly of Jammu and Kashmir succeeded the Constituent Assembly. So the Constituent Assembly referred to in Article 373 must be interpreted to mean the Legislative Assembly now in office. One. And two other aspects. While answering the question by Sri Ajit Joy, used two words, that is wait till the political sting subside. Is it proper for a constitutional court to give leeway for the executive to take advantage of the situation and wait till everything is happened? Lord, sorry, I am making this submission with reference to Israel judgment of the Supreme Court of Israel. They did not wait till the political sting subside, and they have chosen to deliver the judgment when the country is at war with a neighboring nation. And this is widely criticized by the political parties in Israel, saying that when the country is at war with a neighboring state, the Supreme Court of Israel should have waited. There was no urgency at all. And another aspect, you also referred to, the court shall not be in perpetual collision mode with the executive. While adjudicating a dispute in a purely legal manner, the court is only upholding the Constitution. There is no question of any perpetual collision with a majoritarian government. So I expect you to answer these points out.
Yeah, so on your second and third point, it's obviously, I mean, it's not a normative claim I'm making. I frequently, criticize the court for dealing, but also, I mean, I think just it's as a matter of how things work, and not just in India, but, in many other countries, one that often a court, a court that sort of is dealing with these kinds of cases regularly, will always have institutional self-preservation also as a goal, because otherwise, as you know, American history, the Lochner era where the court was frequently striking down, the laws, and then Roosevelt said, look, I'm going to start packing the court, and the court backed down. So there's always this push and pull, and the court always, of course, has to maintain its institutional, or preserve itself institutionally. And often this delay is one ground of doing that. Now it may not be ideal, and I think obviously it's the ground for scholars to critique the court, but I think also to understand that this is going to happen, and it's an inevitability in any country where you have a strong executive that has a large scale mandate. So I think the distinction between saying that it shouldn't happen and realizing that, look, it is going to happen, and so that they're two different things. I think as far as the first point goes, so I think the reason why the Supreme Court disagreed with that is because legislative assembly is a successor to a constituent assembly as a matter of chronology, but not as a matter of the body's nature. So constituent power, which is the power to frame or create a constitution, is not the same as legislative power. And even within constituent power, you have primary constituent power, which is the power the people exercise to create a constitutional order, and secondary constituent power, which is legislatures amending constitutions. And if you're interested, recently the Kenyan Supreme Court has, in their judgment on the basic structure, has discussed that in the BBI case. It's a very interesting judgment. So the Supreme Court basically was saying that, look, the bodies are fundamentally different because they're exercising fundamentally different kinds of power. And so therefore, through an interpretive clause, 367, you can't just replace one with the other because they're not equivalent. So the court basically said that ultimately the legislature may be a successor in chronology, but not as a matter of concepts. It's a distinct body. That was the reasoning that the court adopted in that case.
Hi Gautam, I'm Pooja, to your right. Hi. I wanted your thoughts on the proviso to 370 clause 3 and just how much sanctity there is to the recommendatory power, because I understand that ultimately, the convening of the Constituent Assembly itself might be a precondition to any abrogation or alteration to 370. But what is envisaged under the proviso is ultimately only a recommendation. And while 370 and specifically 3 and proviso stand on a slightly altered judicial and perhaps historical architecture, when it is only a recommendation which ultimately is not binding on the precedent, and what is sought is only a recommendation and not a concurrence, just how much sanctity is there, and a breach of the proviso, how big a spanner does it throw in the works?
Yeah, so I think that point is an interesting one. And so on the one hand you have, so that there are 2 or 3 different arguments at play here, right? So I'll just sort of set them out. So one is, as you say, like the word recommendation and its meaning. The second is that the phrase shall be necessary and its meaning, right? So necessary implies without X, if X is necessary for Y, without X, Y can't happen, right? So that's the second linguistic point over there. Then there is a structural point, which is that if for legislation or a certain kind of legislation you need consultation, for extending the constitution you need concurrence, then for altering the architecture of this whole arrangement, would it be something less or something more than that? That's the structural argument. So all of these are arguments that go into interpreting what the proviso actually means and the sanctity, as you said, which is actually why when you have these multiple readings possible, then it comes down to what you believe is the ultimate purpose of this architecture. And if you believe that the architecture's purpose was to facilitate a final integration, by integration I mean here the equivalence of Jammu and Kashmir with all other states, then you would view with a more lenient judicial eye any step taken towards furthering that goal, and therefore the proviso would acquire less sanctity in your eyes insofar as the action was towards that goal. On the other hand, if in your view the goal of this architecture was to preserve a kind of double consent mechanism that respected both entities on an equal basis as example of asymmetric federalism, then you would treat the proviso as fundamental or binding, right? So I think it came down to what you saw as the purpose of 370 as an architecture of federalism, because the proviso is ambiguous. Recommendation, light sort of word, shall be necessary, quite strong. The design, graded degrees based on what you're doing. So all of that could lead you to reading it in more than one way. And then it comes down to what you think is more consistent with the overall purpose.
One question, yeah, please.
A warm evening to you, sir. Myself, Anand, and I'm a student at Sri.Gautam Law College. I think we all are peoples who contemplate about the ultimatum. From a socio-legal standpoint, how will the open religious and political inclinations of the legislature going to affect the equilibrium of the state upon its birth?
Birth, as in birth of?
Upon a state's birth.
Can you repeat
formation of a state.
Can you repeat the question, brother?
From a socio-legal standpoint, how is the open religious and political inclination of the legislator going to inversely affect the birth of a new state?
As in state of Jammu and Kashmir or?
Yes.
I think he's asking a general question, how the religious and cultural attitude of the government is going to affect the birth of a state. That is
So
what you are trying.
I'm very sorry, not cultural. I would like to deliberate upon the religious and political inclinations, the open religious and political inclinations of the legislator and the center. How are they going to inversely affect the formation of Jammu and Kashmir in the end?
No, the state is, so there's no creation involved in that sense. So insofar as or if or when statehood will be restored, then it will be via the repealing of the 2019 Act, but then it would be on par with all the other states. So in that sense, it's more of a technical exercise than anything else. It's not the creation of a new state in that way. It's just altering the status of the existing state. So I don't think there is a link over there. Of course, there's a link in terms of creating a whole new nation state, but here it's not that exercise, in my view.
By the same I imply to how will it move forward? What is the ultimatum? Like, won't there be an interference of obviously the legislator because of their political, and we know what is happening all around the nation about how their religious and political inclinations has been spread around through their policies and other activities.
Yeah, but that's not the question involving sort of the constitutional alteration of the state as status. That's, I think, more that's more of a political sort of debate, around in broader terms. So, but not with respect to this specific issue.
This is Shivani Dikshit. I'm a second year student at NOAS. So I think as far as the constitutionality of 370 is concerned, everybody has almost asked the question that I had. But I would like to specific idea that you essentially proposed when you were delivering your lecture, when you were in the inauguration ceremony of transformative constitutionalism, organized by Manthan. There you suggested this idea that while there is a constitutionality related matter, there can be a time period structure. Like in a particular time, the Supreme Court should be dealing a constitutional matter. So my question is in twofold. Do you, after 370 judgment, which actually took almost 3.5 years, which it should not ideally be, do you think there is a time to have such a constitutional provisional where they actually kind of prescribe a time limit? And secondly, if there should be a provision, then how do you see it? The formation, the structure, and through which constitution do you take the parallel, like the constitution which has such a provision which actually help them out to get a better solutions?
Yeah, so that's a great question. So interestingly, during the framing of the constitution, one of the framers, I've forgotten who it was, actually wanted a 30-day time limit. So any constitutional challenge, 30 days. That's, I think, not really feasible. And also in Latin American cases, if you have a fundamental rights complaint, then I think 10 days is what they have to decide it in the first instance. Not a constitutional challenge, but like a violation of fundamental rights. But I think one interesting example is the constitution of Kenya, because there they had a lot of violence around their elections, because the elections are very ethnically mediated, and so they used to have large-scale violence after the presidential election. So when they were drafting their new constitution, they said that the Supreme Court will decide, will be the first and the final tribunal for deciding a presidential election dispute. And within 14 days, it must give a decision and then give reasons within 60 days. Now, what that did was that if you look at other countries in Africa, so like for example, Nigeria, what happened in Nigeria recently was that there was an election that was disputed. And then the court sat on it for 8, 9, 10 months, and then gave a decision by which time obviously you can't unseat an incumbent who's been in his seat for a good almost a year. So the Kenyan constitution then says that within 14 days, you must give a verdict. Either you uphold the election or you say fresh elections, and then 60 days they're giving you for a judgment. And in the, and since this came into being, there have been 3 elections in Kenya, 2013, 17 and 22, and twice the court has upheld the election, and once it actually set it aside and said fresh elections. So it seems that that is working quite well, because there has been no real violence after that, and the court cannot avoid, it has to decide. It will either say the guy who was elected is valid and will be sworn in, or invalid and have a fresh election. So it can't escape. It can't, delay. It can't give a judgment that's like, not one. It has to decide one way or the other. So I think something of that kind, might then be helpful. Some provision that says for a certain kind of dispute. Say, for example, a center-state dispute, right? For a center-state dispute, you have to have a certain time limit, and you must give a judgment in that. That might be something to look at going forward.
Good evening, sir. Myself, Fatima Sahala. I am a student of Bharat Mata School of Legal Studies. So, first of all, I want to ask you a general question. Nowadays, we can see that in most of the cases, our judiciary is acting like a puppet of government. Does we have an independent judiciary? What is your opinion about that?
That would be the wonderful question, last question. You can answer.
Puppet of the government.
No, about the role of judiciary in the present situation. That is basically the question that she wanted to ask.
Yeah, so I think that it's important for the court to actually reinforce what I said, the centralizing drift, right? So to try and interpret the constitution in a way that does not make it completely unitary in that sense. So to strictly enforce the guardrails or the lines that effectively maintain that dispersion of power and prevent the concentration of power into like the hands of the executive. So for example, if you look at anti-defection laws, often what happens is that there is this large-scale defection between political parties, and then the court either waits or passes interim orders which ultimately don't solve the problem, and then 1 year later will pass a judgment saying that it was wrong, but now what can we do since the government resigned? That's what happened in the Maharashtra case. So I think that should not happen. I think the Supreme Court's role should be to ensure that the ground rules and the lines that are there between the sort of separation of powers, both vertically between the center and the states, and horizontally between parliament and executive, Rajya Sabha and Lok Sabha, so money bills, for example, money bill cases, and between the executive and other bodies like election commission and so on. So to make sure that those separation of powers is enforced, so that we don't have complete concentration of power in one body, that should be, I think, the main focus in these kinds of cases that the court should adopt when looking at these disputes.
Thank you, Sri.Gautam Bhatia, Advocate Dr. Jacob P. Alex, and Advocate Ramona Nainpalli for this enlightening and insightful session on the Article 370 verdict. I request Honorable Justice Dr. A.K. Jayashankaran Nambia to hand over mementos to the dignitaries as a token of our gratitude and appreciation.
The three of these people deserve a very great round of applause. It was fantastic, Gautam, Ramola, and Jacob. I think it was enjoyed by all, and I'm so glad that many of you joined in to ask these questions, because I think this is the essence of any program that we have here. We need different perspectives. We need people coming up with more questions, and especially Fatima, thank you. You walk right into the lion's den and talk about judicial independence and things like that. Good. There you go, Gautam. Thank you so much. Thank you so
much. Thank you, sir.
I invite Shri K.N. Sujit, Districts and Sessions Judge and Director, Kerala Judicial Academy, for the concluding remarks.
Honorable Justice Dr. A.K. Jayashankaran Nambia, President of the Board of Governors, Kerala Judicial Academy, and the Executive President of ILI, other Honorable Judges of the High Court of Kerala, Learned Advocate General, Learned Director General of Prosecution, Senior Advocates, my lawyer friends, officers, and the law students. So, this evening, so meaningful and so beautiful. Gautam Bhatia, he graciously consented to come over for a lecture, delivered it in a fantastic manner. And on behalf of Kerala Judicial Academy and in Law Institute, I express the profound gratitude
to Gautam Bhatia. Akin to that, the other two moderators, you know how they control the discourse. So both of them really deserves great acclaim. And on behalf of Kerala Judicial Academy, on behalf of Indian Law Institute, I express our profound gratitude to them also. Honorable judges of High Court of Kerala, in spite of very difficult tasks, they also turned up for the function. On behalf of Academy and on behalf of Indian Law Institute, I express our deepest gratitude to them also. Learned Advocate General, Learned Director General of Prosecution, other law officers of High Court of Kerala, they also turned up for this function. We express our deepest gratitude to them also. The judicial officers, accepting our invite, they also turned up. They also and patiently listened to all the proceedings here. I express our deepest gratitude to our dearest officers. My dear law students, some great questions. It evoked some good response from you, and you are the greatest beneficiaries of this evening, this event. We hope to conduct similar kind of programs because the response, the enthusiasm, eagerness which you had shown and exhibited here, which is thought-provoking to us also, and the way in which you dared to ask the questions to our respected dignitary, it really deserves a kudos to you. And you all turned up on behalf of the Academy, on behalf of Indian Law Institute. I express our deepest gratitude to you also. All other officials of the Kerala Judicial Academy, volunteers of Indian Law Institute, other persons who had extended all sorts of help to us, we express our deepest gratitude to you also. Thank you all for participating in this event.
We have come to the end of this enlightening ceremony. Kindly rise for the national anthem.
Janagana mana adhinayaka jaya he Bharat bhagya vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga Uchchala Jaladhi Taranga तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे